sort of deemed ID matters. The first one, Speaker, if I'm not mistaken, was in 2023.
Yes, I think
Correct.
it was.
Now, when you sit at OM, and this ran through the processes we know, and you were involved in the process, when you then sit at OMC and you no longer get reports about this, was this then raised with the ID?
We had a discussion about these matters, and her view has always been that these are sensitive matters that, must remain like that. However, when a matter has been enrolled, then we then talk about its processes, even at OMC, whether it's postponed for trial or whatever the case may be. But at the stage when there is still investigation on it, they weren't discussed.
There was resistance, you say?
They weren't discussed at the OMC. They
weren't discussed. Okay, thank you.
I just understand how it is explained. I accept when people are working that you have a system where one team that's working in the matter, they will keep it within the team. And it's easy to think about a need-to-know principle that, well, people don't need to know, and that's how you manage information. But the idea that matters are sensitive, therefore, they will not be discussed with you, for example. When you hold a particular position, you're head of investigations, you have taken oath, you are bound to the same principles or the same rules as your ID of confidentiality, and if you disclose, you've broken the law. It applies equally to her. How does it get explained, and how do you reconcile with, well, you can't know certain things. A DPP, another DDPP will know, but you can't know, as if you're not subject to the same rules. Can you just explain to us how it is explained in the office and how that is reconcilable with the position you hold?
Commissioners, some of those sensitive matters, as it were, like I indicated, like your speaker matter, they were discussed with me. The explanation about sensitivity stems from the fact that they are matters that sort of the ID owns. They come from her office. She decided on their authorization, and then she decides also who, as opposed to other matters, who is designated in those matters. So, for instance, other matters, as I indicated, it will be the deputies that decides the designations of members who will be part of that team. However, in those matters, the ID herself will decide who she wants to be in those matters. So that is how it worked. And I would, from time to time, get complaints, for instance, from even deputies that you find there are resources in their projects who have been roped in to the ID matters, and they would want them to task them on other matters, and an investigator, for instance, will say, no, I'm busy with an ID matter, and there would be those kind of issues that I have now to deal with, to say, how do I then assist with resources so that the other projects do not suffer, because some resources are put on those matters.
And by that, and by that you mean they will be taken out of their teams Because
Yes.
as I understand it,
Yes.
they all belong to those 4 teams. So they would be taken out of those teams and plonked elsewhere altogether.
Yes, on these projects.
Maybe lastly, so it sounds from your explanation, including the answer to the chair, that there was no, or there was no objective criteria. You've told us about the intake process and what criteria and the scoring that you do about matters that eventually get taken or rejected. The ID matters, as you call them, there was no objective organizational criteria. It was entirely up to the ID. She gets a matter and she decides, however she gets it. If it came to her directly, she decides whether this gets treated like the speaker matter or gets treated like your Project Golden matter, where it's entirely up to her to make the decision.
Yes, that is correct, Commissioner. And that's why I'm saying not all, in fact, almost all matters were dealt with in line with, what I previously said about, being assessed and so forth, either by me or by my other colleagues, the deputies. But those that she made decisions on, that's where there was that a difference, because the approach would be different as compared to other matters.
Thank you. Thanks, Ms. Bang.
And just one more question on this. At a stage where it's clear now, I mean, you are now implementing this process where ID matters are not discussed, at a stage that you can't do your job because there are complaints coming in about resources, there are investigations you know nothing about. Do you again raise this as an impediment to your job and your ability to function?
Chair, we would always find ways, because what we always understood is that when they came from the ID's office, those are priority matters. So we'll always find ways to make sure that these other projects, still continue with whatever, resources we have, move people around so that they can assist. So for instance, if there is a particular tasking in another matter, and then the resource working on another matter is being used in the ID project, then we would find another resource somewhere to deal with whatever tasking that needs to be done on this other matter. So we'll always find ways to ameliorate that challenge.
Okay. Now, you've described in detail the intake process, and we've heard testimony from other witnesses about how it works and how it ordinarily unfolded. Unless the commissioners want to go into detail, my proposal would be, because I think what's different is your explanation of why this multi-level intake process was important. So could you deal with that, unless, commissioners, there's a question around what was set out in the ops manual about how the intake process ordinarily works?
Shouldn't Mrs. Sesoko perhaps start reading from paragraph 16?
Chair, my proposal was that we don't...
We skip even
it,
that. So where do we start?
To deal with why the multi-level intake process matters.
Which is about which paragraph?
At paragraph 23.
Oh,
Yes.
I did not hear that. Yeah. Let's do that.
Yeah. Just for the record, in some, the paragraphs before deal with how matters reach IDAC, the registration process, verification and screening, the intake assessment and the scoring process, the authorization of investigations, the planning and conducting and finalization of investigations, and thereafter securing attendance and prosecution, and ultimately the closure of matters. What's different about your statement is you deal with why this process is important. Can we then go to paragraph 23 of your statement?
Thanks, Chair. Maybe before I deal with that quickly, so I don't want the Commission to be left with a wrong impression. The manual was approved, as I've indicated, and other colleagues have also stated that. It was shared with all the colleagues in IDAC, and when new people come, you know, those responsible DPPs will always workshop it to them. The fact of the matter is the intake process did not operate to the T as provided for in the manual. So that is what the reality was, as you know, my previous explanation had explained about how some of the matters came in. But even though it was not to the T, but most matters would go through that assessment process. And later in my affidavit will show that, in fact, most of the matters that we did in IDAC are matters that came from the commissions, which came in as a result of the presidential proclamation, and therefore did not go through this process, but rather as a result of the presidential proclamation, and the former ID would have authorized them because of that presidential proclamation, and wrote to law enforcement agencies like IPID and DPCI and requested all those matters to come to the ID then for them to be investigated. So I just wanted to clarify that.
Thank you. Advocate Johnson said, for example, about Mr. Adams's referral. She said she did not discuss that with you because it was a simple matter, and she was of the view that she could handle it all by herself without involving you. Are you aware of any instances, or rather, how should I put it? Are you aware that the fact that a matter was simple, whatever that means, that was a factor or a criterion that could be used not to involve other people at the initial stages of a matter or of an intake?
I'm not aware of any except for that specific matter.
And that's not an issue that was ever discussed within IDAC? No. So she never said, with simple matters, I will not bother you, Mr. Sesoko?
No. The decision to authorize that matter was not discussed with me, commissioners. As I will continue my testimony, you'll understand.
All right.
What happened.
No, I just wanted to understand the criterion she said she used in respect of this crime intelligence, these crime intelligence matters.
I would have asked the same question in a different way, so I'm covered by the chair. Thank you.
Thanks.
And then just on the application of the manual, so to the extent that Advocate Johnson testified that the manual was just a draft, she would have been misleading this commission. Well, at its lightest, she would have lied to this commission.
Yeah, I don't understand why she said that. The manual was signed by myself and her, and then at her instruction, it was distributed to all IDAC staff.
Just remind us, for purposes of the record, we've seen it But for the record, when did she and you sign it?
I have a date somewhere. I can't remember the paragraph now. But I do indicate that in my affidavit. I think it was October 2024, if I'm not mistaken.
Chair, it is at file 10.
Paragraph, but in the affidavit, it's paragraph 26, top of foot of
Yes,
page,
yes,
foot of page 11,
paragraph 26.
top of page 12.
Yes, yes.
But Ms. Bowe wants to take us to the document itself.
At page 10 of page 10 of file 10. To the signatures.
Okay, let's,
Yeah.
so it
Yes.
was not a draft, it was signed.
Yes.
Even distributed to.
Yes.
Yeah.
And I do indicate that it was distributed on the, what we call IDCOMs,
Yes.
where it include all staff, on the 22nd
All right.
of October,
Thank you.
2024.
Thank you.
Did it differ much from version 1?
Sorry,
Just look at your screen. Do you see that there's amendment history, the heading, and version 1
yes,
was signed on 18 December 2023, and then the current version 16 October 2024. So did the current version differ much from version 1?
so Commissioner's version 1 was never signed.
Was never signed.
It was a discussion document. As you'll see from my affidavit, I indicated that it was a consultative process. So we had consultants that were assisting us with this document, and then they would send a draft. So the version 1 is the draft that was first sent. We had to engage with it and then make changes on it. And when everyone was satisfied that the version 2 it's the product of what we agreed on, then that's when it was signed off.
And the way things work at IDAC, you know, in other organizations, a document gets signed and then it will have an effective date. And sometimes the effective date will be sometime in the future. Mm-hmm. So with this manual, what was the effective date? Did it take effect from the moment the two of you signed and authorized it?
Yes.
Thank you. Mr. Sesoko, then if you can then go to why the multi-level intake process matters.
Yes. So I emphasize the intake and case selection process, case selection stage of the process, because it is deliberately multi-layered and collective. Its stated objective is that case selection is transparent, objective, auditable, and defensible, and that it cannot be manipulated. There is, however, a further and equally important object: to insulate the ID from any allegation that IDAC is targeting particular persons or picking or declining cases without proper basis. If a matter is received, assessed, and scored and recommended by a team and a committee before it reaches the ID for authorization, the ID decision rests on a documented defensible foundation, and the ID is protected against the very allegations that are now being made. I was closely involved in creating this framework. I drafted the case intake process that became a case selection criteria, Annexure A to the manual, in August 2022, and I'm a signatory to it. The purpose of that process, as recorded in the document itself, was to establish a case intake and selection process that is impervious to undue external influence and that ensures IDAC is not manipulated to select cases furthering a personal or political agenda It provided for case intake to assess matters and advise the ID. In 2024, IDAC embarked on an inclusive process involving members across the department to produce the operational manual, which sets out processes in detail and incorporates the intake criteria. The operational manual version 2 was signed by me as head of investigation and operation and by the ID on the 16th of October 2024, and it was shared with every staff of IDAC on the 22nd of October 2024 at 11:31. It is, in substance and in the manner of its adoption, a policy of the unit. The framework contemplated a single designated intake point together with the case intake committee. It motivated for a dedicated post to fulfill this function.
I think you say here I, not it. So I motivated.
Oh, sorry, I motivated for a dedicated post to fulfill this function. A person who would receive all incoming complaints, conduct first assessment of whether the matter falls within the mandate, refer qualifying matters to the case intake committee, and act as its secretary to that committee. The object, again, was to ensure that the ID does not take intake decisions alone, and that she is insulated from allegations of targeting a particular person or having an interest in particular investigation. The job description for that post records these functions. Incumbent is to receive and register all incoming cases, evaluate whether they are within mandate, refer out of mandate matters, convene the case intake committee, and act as its secretariat. See the attached job description marked MS1. I initially designated the post investigating coordinator. Through the organizational development and job evaluation process, it was retitled Deputy Director, IDAC Operations Support, and graded. The post was placed before the job evaluation panel on the 25th of November 2025. The recommendations were approved by the minister on the 31st January 2026. The post was graded at level 12, and feedback on the outcome was provided on the 5th of March 2026. I attach the confirmation of the job grading marked MS2. The process to create and fill that post was, however, not carried through. When I followed up with the organizational development unit, I was informed that they had been instructed to stop the process on the basis that the post would not exist and that the responsibilities would not lie with it, pending a restructuring. The outcome was not communicated to me at the time. I only learned of it on the 27th of July, 2026.
You say this in the passive voice. You say you were informed that they had been instructed to stop the process. And who had instructed them?
The ID.
Thank you.
You can continue.
The consequence is that the single intake point and the case intake committee were never fully operationalized. In practice, matters continued to be received directly, mainly through the IDAC spokesperson, including by the ID herself and me, and were not always routed through the collective assessment that the manual and the case intake criteria contemplates. It is against this background that I raise a concern of general application and not as a comment on the guilt or innocence of any person. Where a multi-level intake process is bypassed and a matter is received, assessed, and authorized by ID alone, the very protection that the process was designed to provide objectively, auditably, and the insulation of the ID from allegations of targeting falls away. That, in my respectful view, is the significance of the process for the Commission work. I'm aware that the operational manual has been described before the Commission as a draft. I record that the manual was signed by the ID and me and was distributed to staff, to every employee of IDAC as an operational manual. A review of the manual was subsequently undertaken by a single person, which is different from the inclusive consultative process by which the manual was originally made. In my experience in government, a policy of this kind is developed and reviewed through a consultative process and remains applicable until any review is completed. I have not seen the review.
Was there an actual review?
Yes, I've learned that there was the actual review.
Have you seen a document?
I have not seen the document.
How did you get to know that there was a review?
It was discussed in my discussion with the ID. He indicated that she had instructed Advocate Mohammed to do the review. We also had an investigators working session where Advocate Mohammed was in attendance, and she indicated that she was in the process of reviewing the manual.
Is Advocate Mohammed within IDAC or is...
She is within IDAC.
Oh. All right, thank you.
In what position? Sorry.
Except my question, is she a prosecutor? What's her position in IDAC?
Yes, she's a senior state advocate.
Thank you.
Not at the level of a DDPP.
No.
All right, thank you.
As matters stand, you say you haven't seen that reviewed manual, but you know that there is a manual. To your knowledge, as matters stand, what is applicable, even if it's not being applied? Is it this new version, or you still, to your knowledge, at version 2 that's supposed to be applied?
Chair, as a matter of process, as long as the reviewed manual has not been approved, the original manual still stands
You would be
and
one
remains
of the
operational.
You would be one of the approvers by virtue of your position.
I'm not sure with the reviewed one.
Okay. So you're
Because
saying,
I was not part of the review.
okay. Now I'm just trying to understand. You were a signatory to version 2.
Yes.
And I have assumed by virtue of your position as the investigate, you are the head of investigations.
Yes.
So I assume that's why you signed this manual.
That is correct, because it was, as I said, a consultative process. And we would discuss extensively also with the ID and the other colleagues. So after that consultative process, and I presented it to her, we agreed that it's ripe for approval, and then that's why I signed off on it. The review process, as I said, I wasn't part of it, so I cannot say to the commissioners now that I was going to sign or not, because I'm not sure.
Okay. Thank you.
Did this?
What does the manual say about consequences for failure to follow its processes? Does it say anything at all?
Yes,
So say, for example, a case comes in, the case assessment report is not there, that CIS process that you mentioned, I hope I'm saying it correctly, if all of those processes are not followed, what does the manual say will be the consequence?
I think the manual does allude to the fact that failure to comply may lead to a disciplinary process.
But the ID can discipline herself. So if she's the one who's flouting the manual, does the investigation continue even if the processes set out in the manual are not followed? That's really what I'm getting at.
Commissioner, obviously, if the ID herself flouts the manual, then the person that she reports to would have the responsibility to take that action,
So that would be the
the
DPP.
NDPP.
Does the manual say it applies to her or only those below her? Can we just clarify that? Does it apply to everyone at IDAC or only those below the ID,
It applies to everyone,
including the ID?
yes.
Let me ask a related question. Are exceptions provided for? There is exceptions not to follow the process strictly. Are there provisions for exceptions?
Chair,
With
on the
regard
top
to-
of my head, I can't remember if there were exceptions. But
Can you?
my understanding of
Yes.
the architecture of the NPA Amendment Act is such that the investigating director has got all the powers to decide on anything, including deviating. So, for instance, even with authorization, that she can, Meromutu, decide on an authorization.
Can you please look at the manual during the T adjournment and see if the manual itself does provide for exceptions? I hear you on what you say about the Act. Did you refer to a specific section?
Yes, it's section 28(1), I think.
20.
Yes,
Isn't 28(1) about investigations?
yes, on the authorization that she can, Meromutu.
But I'm not sure that that answers my question about exceptions with regard to the application of the manual.
Yes, no, that does not deal with that. Commissioner.
I thought so.
I will check the manual as suggested.
All right, please, thank you.
Mr. Sesoko, you said that I think it was in response to Commissioner Kumalo that it would be the NDPP that would have, and how would the NDPP know?
Obviously, there should be reports that go to the NDPP.
And the reports would come from the ID?
No. If I understand you well, you mean if there is an issue about non-compliance?
Yes.
Yes, so if there's an issue about non-compliance, it means employees who become aware of the non-compliance, who reports it to the NDPP would have to take action about it.
So essentially, employees would have to report to the NDPP?
Yes.
You know, the natural question that follows is, in these instances, we know there was flouting of this manual, and you were well aware of that.
Yes.
Did you report to the NDPP?
I personally did not report, Chair, but I'm aware that I was informed that there were a number of complaints that were referred to the office of the NDPP, the former NDPP.
I may have misheard you. Did you say that you cannot or you did not report?
No, I did not report.
Is there a reason?
Chair, I don't have a reason why I did not report. I think I say something about it later in my affidavit. I have been through a lot, and when some of these things happen and you hear that, you know, there were reports that were reported to the former NDPP, and there was nothing that happened. You know, I just felt that it won't assist me anyway.
Now it looks like you were part of the problem. Two of your colleagues came to this commission and they could show us emails that they wrote in 2024, 2025, raising serious concerns. Although nothing was done, it's clear from their emails and their communication that they raised concerns about how things were done. You now have to account to us, and you did not do anything. And
Yeah.
because you did not do anything, it looks like you were part of the problem. You were part of the reason why the manual was not followed to the letter.
Chair, I will take responsibility for that, but I had my own personal reasons. The fact of the matter is, these issues, as they were raised, and you would have seen in the emails, the colleagues were sending these emails to the ID herself, and I'm copied in those emails. And in bilateral meetings with the ID, we would discuss these issues. And she would indicate, for instance, his displeasure about the colleagues on how they raise these issues or raising these matters, because she believed that there was nothing wrong in how they were approaching that case. So I left it at that.
You mentioned in your response that you were copied. In some of those emails, they were sent directly to you. And particularly, I know one of the witnesses, Mr. Rapesu, you would have been also his supervisor, because that would have come out in the investigation side of things. So, and you say that in then discussions with the ID, she would raise displeasure about them raising these issues. And in response to that, then nothing is done.
And as it relates to Mr. Rapesu's issues that she raised with me, I took them up with Chief Perumal. And in those discussions, Chief Perumal would make it look like there's a difference of opinion in the investigative approaches. So part of what I would want to do is to try and get the team to be coherent. So I tried to sort of mediate whatever conflict they have about a specific issue and how an issue is dealt with. So that's how I approached it.
But I'm sure you could tell that there's a difference between what you call a sort of a difference in approach, or when Chief Perumal says to you, it's more of a difference in approach, that there's a difference between that and blatant disregard of rules, the law. When you are then dealing with those issues and that occurs to you that that's happening,
Yeah.
Surely there's more to be done than just building coherence in the team.
So, as far as I can recall, the issues that Rapesu raised with me was in relation to the process of the issue relating to one specific witness and how that had been approached, and the instruction from Chief Perumal, which he was uncomfortable with, which, as I said, was discussed with them. But not long after that, that is when he was removed from the investigation.
Okay.
That's how I recall it.
It's fine. I think we will, in the sections dealing with your involvement deal with some of the issues that were raised. And I think the records will show that it's more than just a difference in approach. There was
Okay.
actual disregard of both your internal operations manual and I would say the law as well. We can then move to the next section of your statement, which deals with your involvement in the crime intelligence-related investigations. Chair, and characteristic to seek an
Let us
early
start.
adjournment, but
Let us start. Were you going to say?
I was going
maybe
to say, because this is the second half of his statement.
Let's start. Yeah.
No problem.
We can stop at 11.
All right. Mr. Sesoko, then we can move to paragraph 33, where you deal with your involvement in the crime intelligence-related matters.
That's correct. Before dealing with the detail, I stated at the outset that I had no direct or substantial involvement with these matters. I was not included in the team, and in the ordinary course was excluded. Sometimes Chief Perumal would mention something to me in passing about a case and how good evidence he had obtained. I think there were a number of meetings where I was invited, which I cannot remember details of. I came to learn of aspects of the matters largely when complaints were reported. Given the position I hold and the leadership role I ordinarily play, the exclusion was unusual and had not previously occurred in my time at IDAC. I was drawn in only in discrete issues. There were, in essence, 4 occasions on which I had involvement. Assisting Mr. Rapesu to obtain the docket, a meeting convened by the ID to discuss the CI investigation and a report to the minister, a conflict between Advocate Ramsamy and Chief Perumal, and the disciplinary and legal matter concerning Mr. Rapesu.
I think it's important to mention which minister. Please reread.
Minister Mkunu. Minister of Police Mkunu.
I just meant of police. You just said
Yes,
minister.
Minister
only.
of Police Mkunu.
Thank you.
You can then deal with the first issue, which is when you were assisting Mr. Rapesu to obtain the dockets.
Yeah. On or about the 6th December, Friday, I received a call from an IDAC investigator, Mr. Rapesu, who informed me that he had been instructed by Chief Dylan Perumal, to fetch the dockets containing the allegations against the CI officials from the station, and that he had been told the dockets were held by the inspectorate with General Jacobs. Because of the level involved, he asked me to facilitate. I telephoned General Jacobs and told him that the investigators would like to see him in relation to the dockets in his possession. He did not inquire why. He did not seem surprised. It was a very short conversation, and he said that I could come and see him. I think I meant he could come and see him. At the time, I did not know.
He is in Mr. Rapesu.
Rapesu, yes. At the time, I did not know whether the investigation was authorized. I